Excellent. Well, welcome everybody to the NorthStandard Summer 2024 Sanctions Update. My name is Mark Church, and I'm delighted to be here with my colleagues Mike Salthouse, Gina Venencia, and Ursula O'Donnell. And we're just going to have a quick canter through some of the key issues and trends which we think you should be aware of when it comes to sanctions in 2024. I'd say at the start, if you've got any questions, please do just pop them in the chat, and then we'll do our best to try and answer them at the end of the session. So what are we going to look to cover today? Well, firstly, Mike's going to just set the scene and provide a little bit of context as to where things stand right now. We're then going to look in a little bit more detail at some of the key sanctions updates, particular focus on Russian sanctions and on Venezuelan and Cuban developments in the US. Then we're going to take a little bit of time just to consider how we as a P&I club approach sanctions matters. And then the final two topics, which I think will be of interest to hopefully a lot of you on this call, we're going to look at some of the steps which have been taken recently when it comes to enforcement. And then we're going to try and gaze into our crystal balls and tell you what's likely to be coming down the road in the next 6 months or so. So without any further ado, I'm going to hand over to Mike, who's going to do a bit of scene setting for us. Mike, over to you.
Great. Thanks very much, Mark. Hello, everybody. So I think the first thing I'd like to say is sanctions really are designed to achieve a foreign policy objective without the use of armed force. So they're very high up in terms of the sort of priority list in terms of the toolkit that states have to achieve their foreign policy objectives. And they are trying to achieve things which are obviously brought about by something creating considerable amount of international tension, whether that be to prevent certain states from acquiring nuclear weapons or restricting a nation's ability to wage war. And the point I want to make is really that, for us as commercial entities, if we get in the way of that, then we will be sacrificed to the overriding foreign policy objective, because those foreign policy objectives are so important. So we're seeing more sanctions. Really, I don't think that will come as a surprise to anyone. Really, since 2010, sanctions have been the foreign policy tool of choice. They focus particularly on the shipment of oil, for the simple reason that oil is an essential engine of economic growth, with something like 86% of nations being net importers of oil. And economies of countries that produce oil historically are heavily dependent on its production and export. So a third of Russia's economy, for example, is based on oil and gas. And Russia is the world's second largest producer of oil, Iran, I think, the fifth. They are today of unprecedented complexity, and there's a number of reasons for that. Firstly is simply the scale. They are now at a level unlike anything we have seen before. For certain jurisdictions, Russia being the most obvious, pretty much every shipment will need to be checked against multiple legislatures and also product codes. And then different jurisdictions such as the European Union, UK, US often target the same trades or practices, but in different ways, reflecting differences in their legal systems and their jurisprudence. The oil price cap, when we come to that, is not simply a ban, but it's actually trying to exert control over the price of one of the world's most widely traded commodities. Industry is not subject to a prohibition, but it has been made the agent of enforcement responsible for checking the price. And whatever you might think about the oil price cap, states think it is working to a degree. So we are likely to see more of that type of measure introduced in the future. And lastly, when it comes to the complexity that we now face, I would say that we're also increasingly starting to see sanctional dysfunction. So sanctions authorities do not always agree, and Mark's going to pick up on some of the areas where there are differences between the European Union, the UK on one hand, and the US on the other in the future. But at its most extreme, this can translate into blocking legislation that exists in the case of Iran, with the EU, UK on one side and the US on the other. And it's worth noting that China has also enacted blocking legislation. It simply hasn't annexed any particular foreign legislation to that statute yet. So there's no active blocking in place, but the mechanism, the toolkit, is available to it. There is a big focus on shipping. We just have to accept that. Shipping moves 90% of everything. So if you're imposing financial and economic sanctions on a state, then it's likely that shipping is always going to be affected. And the other reason really that it's so focused on shipping is that the people who support shipping, people like ourselves and banks, tend to be domiciled and regulated in jurisdictions where it's very easy to enforce breaches against ourselves. There is no sign of enforcement, there's no sign of the current geopolitical flashpoints easing. Iran, Russia, DPRK, these are mature states with a mature sanctions program. The only significant easing of sanctions that I've seen in the last 14 years was the JCPOA in 2016, and that was largely reversed by the US withdrawal from the JCPOA 2 years later in 2018. I don't need to tell anybody about the catastrophic impact of a sanctions violation. Designation from the US will prevent normal business functions really until such time as it's lifted. To quote Mr. De-Designator, as I would call him, which is Matt Thomas at Blank Rome, it is the US acting as judge, jury, and executioner, but in reverse order. And there's very little due process in the system of designation. A lot of the intelligence that's relied on is secret and therefore is not disclosed to the party that's actually being the subject of the designation. So few businesses can withstand that. And then there, of course, there are other penalties, which include substantial fines and imprisonment, particularly here in the UK. And then the reputational damage, particularly if you're involved in financial services. So we're seeing more and more vessels being sanctioned. There was another vessel sanctioned by the US yesterday, and increasingly managers are being targeted. The UK has started to replicate the secondary sanctions that we've grown used to from the United States. Most recently, we've seen BEX and Active specified by the United Kingdom. So on that not particularly upbeat note, back to Mark.
Thanks ever so much, Mike. So just turning now to some of the key sanctions developments over the last few months, which we think it's worth you being aware of. Just taking a step back, the way that we tend to look at sanctions matters, and we'd encourage you to think similarly around sanctions, is to break questions into two areas. Firstly, if you like, the who's involved, which parties are involved, which vessels are involved in any particular trade, and then the what. What is the activity that's being contemplated? Because even if there are no sanctioned individuals or companies involved in a particular trade, obviously, if that trade itself is subject to sanctions, then that's going to impact upon your ability to perform that voyage. So looking at sanctions developments in each area, if we look first at party-related sanctions, well, of course, the US, EU, and UK sanctions lists of designated and sanctioned individuals and entities is publicly available. So the context here is that the regulators have all made it abundantly clear that the absolute minimum expectation on you and on us is that we are checking those publicly available lists. What many companies, including ourselves, now do is go at least one step further than just checking the publicly available lists, and that is to subscribe to screening software such as WorldCheck, which we use, but there are many other good commercial tools out there which will help with your sanctions screening. And what this software can do is not only scan the US, EU, and UK lists, but a whole host of other countries' lists, and also will give you some information around ownership and control. Now, I guess some of you on the call may be thinking, well, do I need to be interested in the UK list, for example, if you're not a UK individual or company? And what I would say is I would just encourage everybody to think about the sanctions that may impact not only on them, but also on your business partners and not least your insurers, because we as an insurer obviously need to, being based in the UK, will need to comply with UK sanctions. So even if the sanctions are not directly applicable to you, they may well have an impact on the performance of a voyage and the insurance of it. Now, when it comes to party-related sanctions, what are the trends and challenges in this area as we see them at the moment? I think one of the key trends post the Russian invasion of Ukraine has been the UK and the EU in particular. Yes, as Mike has explained, they will designate vessels, they will designate ship managers, but also there's been a whole host of individuals who have been sanctioned. So, particularly Russian oligarchs and businessmen, they have tended to be sanctioned by the EU and the UK. And then when you look at the reasons given as to why they have been sanctioned, it will often say that that individual is associated with particular companies, and those companies may be named in that designation of the individual. But when you actually look up those companies, you'll see that they are not expressly sanctioned themselves. So you have an individual who is linked to a company being sanctioned, but not the companies to which we know they are associated with. And the EU's provided some guidance here and said that operators need to exert the highest caution when dealing with associated persons or entities. If these non-listed entities are deemed to be owned or controlled by a person who is listed, their assets must be frozen as well, and no funds or economic resources can be made available to them. So there's this concept not only of ownership, but also of control. And the EU and the UK sanctions require you to do a control analysis to see whether the company that you are dealing with is deemed sanctioned, even where they're not expressly listed. So you can quite often end up in a situation where you know there is an individual linked to that company who is sanctioned, but the underlying company is not expressly sanctioned themselves. And you have to try and therefore establish, does this individual have control over that company, which means that that company is also subject to sanctions. And obviously, when you're dealing with companies in Russia or even in Iran or elsewhere where there's likely to be a number of sanctions targets, it can be really, really tricky to dig down into that corporate structure and take a view on the level of control that an individual has over that company. And unsurprisingly, perhaps in recent months, we've seen some cases flowing through the English courts to try and establish what level of control is necessary. And there were some comments in the Mintz judgment, which is mentioned there, which caused quite a few alarm bells to start ringing, because one of the individuals who is sanctioned is President Putin himself. And the comments by one of the judges in that case was that in a very, very real sense, and certainly in the sense of the UK sanctions regulations, Mr. Putin could be deemed to control everything in Russia. So query, does that mean, therefore, that basically every Russian company should be deemed to be sanctioned because Mr. Putin has a level of control over almost everything that happens in Russia? Now, perhaps unsurprisingly, there's been a bit of rowing back from those comments. The Foreign Commonwealth and Development Office in the UK issued a statement basically saying that's not effectively what control means in this under these regulations. And there's been a more recent judgment in Litasco where what they're saying is just because Putin could place a company under his control does not mean he controls that company for the purposes of the regulation. You're looking at existing influence. So what control is actually being exercised, not what control could be exercised by an individual. Where this all gets us is a pretty messy picture, I would suggest. And it does mean that for you and for us, actually establishing whether Russian companies in particular are not sanctioned can be extremely difficult, because you're trying to establish whether individuals linked with that company have a level of control over it to mean that the company itself should be deemed to be sanctioned. I think one of the other challenges in this area relates to what happens when you get no hits back from screening software. So you're looking at charterers, for example, who maybe you haven't done business with before, and you do some sanctions checks and there's no information about them. And I think just a note of caution here, not to consider that getting no hits back necessarily means that there are no sanctions issues at all. What it might mean is that that's a new company, perhaps been set up to circumvent sanctions, and there may just be no information yet about it on that screening software. So that's just a little note of caution, I think. If you get no hits back, just be a little bit careful about considering that to be a green light to continue business with them. Now, moving on to the second area of sanctions, which is the activity related. Mike's already briefly mentioned it, but the one that's obviously got most publicity, a lot of scrutiny, is the introduction of the oil and petroleum products price cap. Just a quick refresher as to what these relate to. So these are price caps for the transport and the insurance of that transport from Russia to third countries, i.e. non-UK, non-EU, non-Russia, non-US, sorry, from Russia. And this is crude oil and petroleum products. It applies to CN 2709 and 2710 cargoes. And there's been a lot of debate about whether these price caps are working or not. And as a response to some of those concerns as to how it could be working better, additional requirements were introduced from 20th of February of this year. So what needs to happen now is, in order for us to be able to provide cover, we need what we call a SPIRE report, which is details of the Russian voyage. Just pausing there, that requirement is not unique to oil and petroleum product trades. That is a requirement for all Russian voyages, whatever is being carried. In addition, if it's a price cap trade, we also now require a voyage-specific attestation to be provided to us in the prescribed format as set out in our circular earlier this year, and that needs to be provided within 30 days of loading. And that's absolutely critical. The annual attestations, which could be provided up until 20th of February, no longer acceptable. We do need those voyage-specific attestations. And we also need members to have a right to obtain the ancillary cost information and have a right to get that on demand, because we may well be asking for a copy of that as well in the post 20th of February 2024 world. There is also one other significant requirement, which is there is an obligation to do appropriate customary due diligence. Lots of debate about what that actually means in practice, and perhaps a lot of noise, but not a lot of clarity about what is actually constitutes customary due diligence. What I would say is we would expect, I think, members to be a lot more cautious and to do additional due diligence where we know the market price is above the price caps. So if you're considering entering into a voyage and we can see that the market price is above the price cap, then of course that should be a cause of particular concern and a need to dig in even further into whether actually what you're getting told from the charterers and what the documentation you're getting, whether that can be safely relied upon or not. Of course, a lot of publicity around the price caps, but let's not lose the fact that actually there are a huge number of other cargoes which are impacted by sanctions, both cargoes potentially going into Russia and coming out of Russia. The last time I looked at the Russia sanctions EU exit regulations, the UK regulations, they were now over 500 pages long. And the number of cargoes impacted, as I say, is now huge, both under the EU and the UK sanctions. One of the really tricky things is, although the policy goals between the EU and the UK are obviously the same, there is divergence, significant divergence in the detail of the cargoes which are targeted by the sanctions. So whether it's petcoke, some steel cargoes, you really do need to be comfortable both under the EU and the UK sanctions, and just looking at the EU regulation and saying, okay, this cargo is not covered, it's not focused, it's not targeted by the EU sanctions. That doesn't necessarily mean that it's not a target of UK sanctions, which again is another factor in just making things difficult for you and difficult for us in just establishing whether cargoes are okay to be carried or not. It's not just in the UK and EU, though, that there has been sanctions developments, and indeed it's not just in relation to Russian sanctions. So I'm going to hand over to Gina, who's going to give us an update as to what's been going on in the US.
All right. Hello, everyone. So I'm going to address both Venezuela and Cuba and kind of highlight some of the recent developments with respect to sanctions targeting those two countries or regimes. For Venezuela, take a step back for a little bit. Everyone will know or recall that the Venezuela oil sector has been under U.S. sanctions for quite some time. And those sanctions have been in existence with respect to the oil sector and PDVSA itself. Now, while those sanctions provisions did not have a clear secondary sanction effect, one that applied to non-U.S. persons, when the oil sector and PDVSA sanctions were implemented, put into effect, it became very clear that the U.S. was going to apply those provisions in a secondary sanction fashion. So those sanctions severely restricted, if not almost entirely eliminated, Venezuela's oil sector transactions. In the fall of last year, the Biden administration decided to ease the sanctions against Venezuela, and one form of that easing was with respect to the oil sector and PDVSA. So last fall, via General License 44, the U.S. authorized transactions involving the oil sector and PDVSA. So that lifted what had been a very restrictive aspect of U.S. sanctions. So both U.S. persons and non-U.S. persons were able to engage in Venezuelan oil-related transactions, subject to certain conditions that were set forth in the General License. The U.S. made very clear that it was going to monitor developments in Venezuela and that this easing of sanctions would be temporary if the U.S. felt that Venezuela wasn't holding up its bargain. So fast forward to the beginning of this year. That's exactly what happened. The U.S. felt that Venezuela did not hold up its bargain and indicated that the easing of sanctions would itself terminate. So the easing of sanctions with respect to the oil sector, General License 44, terminated in April, but then they issued General License 44A, which provided for a wind down period for any transactions that were previously authorized by GL 44 to be wound down and completed by May 31. Now, that has come and gone. So as we sit here today, the sanctions provisions with respect to the Venezuelan oil sector exist as they existed a year ago, 2 years ago. So the oil sector itself is designated, and PDVSA is itself designated as an SDN. So that General License 44 no longer permits those transactions that would have been permitted in that limited period of time between October and through last month. But it's important to remember that there are other general licenses that are still in effect that do allow other trade with Venezuela, including with respect to Venezuelan oil. And specifically, I'm referring to what's known as the Chevron general license, and that's general license number 41. Make sure I got that number right. Yes, 41. Now, general license 41 is a very limited authorization, but it permits Chevron, which has a JV in Venezuela, to engage in certain oil-related transactions, including the lifting of oil out of Venezuela and the transportation of same. There are conditions in General License 41, including, by example, that any such transaction can have no involvement of entities owned, controlled, or existing in Russia. So again, there are still limitations on GL 41, but it's out there. So if you get asked there's an inquiry about the transport of Venezuelan oil, you really have to do a close examination to see if you can fit within GL 41, but GL 44, the more general authorization to engage with PDVSA or Venezuelan oil, is no longer in existence. The other point to remember is that U.S. sanctions and the ability to sanction someone doesn't have a firm statute of limitations. So someone may think, if I engage in an activity which wasn't sanctioned by the Biden administration, that means with the administration changes, that means that it's unlikely I will be sanctioned. That's not necessarily the case. So if we happen to have a change of administration next year, or even if we don't have a change in administration, activity that occurs today could still be subject to sanctions a year from now. And we did see that with Venezuela several years ago. There were shipments that occurred 9 months later, almost a year later, where the U.S. came in and issued sanctions against foreign ship owners and against ships that were involved in Venezuelan oil trade. Now, notwithstanding the limitations of Venezuelan oil, I think it's important to remember that there is still lots of trade with Venezuela that is permitted. The sanctions targeting Venezuela receive a lot of press, a lot of inquiries, but when you really look at it, it is limited and it's targeted at certain actors, certain industries, oil, which happens to be a significant industry, but there's still a lot of trade that is permitted, particularly for non-U.S. persons. And even for U.S. persons, there are general licenses that are in place that allow U.S. persons to engage in activities with the government of Venezuela. And I always hit this point because I think there is sometimes confusion about how the sanctions against the government of Venezuela actually exist. So the government of Venezuela and any entities owned or controlled by it are blocked. They're blocked by executive order, but they are not on the SDN list unless specifically identified. So I try to explain to people that all SDNs are blocked, but not all blocked entities are SDNs. And in the Venezuelan context, the import of that is U.S. persons generally cannot engage in activities involving government of Venezuela entities, but non-U.S. persons don't face that same restriction. But the U.S. recognizes that there is lots of trade that is permissible even for U.S. persons in Venezuela, but they might have a government connection. So the way that is addressed is through general licenses. So a general license that does come into play is General License 30A, which permits activities involving the government of Venezuela related to the use of ports. So if a governmental entity owns and operates the tugs, it's permissible to engage with that entity for purposes of using the port, provided that the underlying activity is not sanctionable. There's also, as we see in almost all sanctions programs, there's a general license which permits agricultural commodity transactions, medicine, medical devices. One of the questions that we received prior to the webinar was, do those general licenses permit payments in US dollars? And the general answer to that is yes. So those two general licenses would technically permit US dollar transactions with respect to permissible activity that is set forth in the general licenses. But you have to remember that this is where the bank's appetites may come into play. And a bank may simply be unwilling to engage in a US dollar transaction if any of those government entities are involved, any Venezuelan government entities are involved, because they just don't want to get involved in having to do an analysis. So while technically those licenses should permit US dollar transactions, it's generally, we don't see that often unless you're dealing with U.S. persons, but we don't see it frequently with non-U.S. persons because of the risk of the banks. So now Cuba. So Cuba has been subject to very extensive U.S. Sanctions for decades, over 50 years. But that sanction program is primarily directed to U.S. persons, and that includes U.S. companies and their foreign-owned or controlled subsidiaries. This U.S.-Cuban sanction program does not have secondary sanctions similar to what you see with other countries. Nevertheless, non-U.S. persons can be subject to U.S. sanctions if they engage in Cuban trade and there's a U.S. nexus to that trade. So one of the most common U.S. nexi is U.S. dollars, right? Because almost every U.S. dollar transaction in the world has to be routed through at some point in time a U.S. bank. And so non-U.S. persons free to engage in Cuban trade, but generally speaking have been unable to do so in U.S. dollars. And that would include any type of transaction that might have a connection to the Cuban trade. Well, just this last month, the U.S. eased one aspect of the Cuban sanctions regulations that is applicable to what I just described, and that is non-U.S. person trade and the inability to utilize U.S. dollars. So the U.S. has eased those restrictions by authorizing what is known as Uturn Transactions. And this was something that first came about during the Obama administration. It was revoked during the Trump administration, and now it has been reinstated by Biden. And what that allows is it allows U.S. banks to essentially act as an intermediary bank for transactions having a Cuban nexus if the originator is outside of Cuba and the beneficiary is outside of Cuba, and there's no U.S. connection otherwise to the trade. I do want to make a point of clarification. There are plenty of licenses in the Cuban sanctions provisions that allow U.S. persons to engage in Cuban trade. There's general licenses, there are specific licenses. If there's a license in place, then U.S. dollars can be utilized. U.S. banks are protected by that license. But in the case of non-U.S. persons, you don't need necessarily a license. It's just that you're not subject to the sanctions, but the U.S. banks would be. But now U-turn transactions are permitted. Again, the general concept is that the money is coming into the U.S. from someplace else, but it's making a U-turn and getting out of the U.S. Rather quickly, and that is currently permitted. And it is a form of an easing of sanctions with respect to Cuba. And so with that on Cuba and Venezuela, I'm going to turn it over to Ursula.
Ursula, are you there?
Sorry, I'm not sure what happened there. Hello, everybody. Thanks, Mark. This slide shows all jurisdictions which are considered to be high-risk areas by the club. So that is Russia, Iran, Syria, Cuba, Venezuela, Ukraine, and North Korea. And what this means is that this doesn't mean that you cannot trade to these areas. It's still lawful to carry out trades to each of these jurisdictions except North Korea. But what it does mean is that if we are notified about a claim linked to any of these jurisdictions, we have to carefully review to check whether any parties linked to the trade are designated to a sanctions list or are owned or controlled by an entity or an individual that's been designated to a sanctions list. And also to check whether the trade itself is subject to sanctions or whether it's prohibited to provide insurance in respect of the trade. Because although it may be lawful for a member to undertake a particular trade, it may be unlawful for the club to provide insurance in respect of that voyage. And whilst the club will always try to assist members, and we will cover a claim if it's lawful to do so, we have a zero tolerance in respect of sanctions breaches. And what that means is that we cannot cover a claim if it arises from a sanctioned trade. And if a particular trade exposes the club to the risk of breaching sanctions, or the provision of insurance is prohibited, that will trigger the club's cessor rule, which means that cover is automatically terminated. So, for example, if a member is designated to the EU sanctions list, that means cover is terminated from the date of the designation. Another thing to bear in mind is that we are an EU and UK regulated insurer, so we have to comply with EU and UK sanctions. And what that means is that we apply them uniformly across our membership, whichever club entity is insuring the business, and that includes business insured by our subsidiary company in Asia. Can I have the next slide, please? We're very pleased to say that we have a dedicated sanctions advice team, and there's 26 people in the team, and they are spread out across the club. They're based in our overseas offices in New York and in Greece and in Singapore, as well as our 2 UK offices, and they have a great deal of experience in advising on sanctions, and they can assist in terms of responding to general sanctions queries about a particular sanctions regime, or to advise about a particular trade, or to advise about a particular contractual clause. But what we can't do is to provide due diligence on behalf of a member. You know, the duty to provide due diligence is on the member. They can't delegate that duty to the club. And we also cannot confirm whether cover will remain in place for a particular trade. And that's simply because further sanctions may come into effect during the voyage. We always recommend to members that the best form of protection in respect of sanctions is really to have appropriately worded sanctions clauses in their contracts. And whilst it doesn't offer complete protection, because you can never guarantee whether a charter is going to honour any warranties or indemnities that they are supposed to respond or honour under the terms of a sanctions clause, it does offer the best protection. BIMCO has drafted a whole suite of sanctions clauses in respect of a variety of standard form contracts, and that includes a sanctions clause in respect of the Russian oil price cap scheme. And that's been recently updated, as Mark referred to, the requirements for to provide a per voyage attestation, and also to provide details of the ancillary costs if required to do so. And Mark, in fact, was involved in the drafting of those clauses. And we also have a lot of resources available on our website that can assist. We have a sanctions guide, which provides details of US, EU and UK sanctions that apply to all the high-risk areas that I referred to in the previous slide. Also provides guidance in terms of the general of due diligence that members should carry out. And we also regularly post news items on our website in respect of any recent sanctions developments. And we also have a podcast called Alongside, which has covered sanctions and geopolitical risks, which was actually hosted by Mike Salthouse. And I think I'm actually now handing over to Mike.
Thank you very much, Ursula. So if we have now a look at, just as an echo on, yeah, good. So if we have now a look at the issue of enforcement. For those of you who don't know, the United Kingdom's Office of Financial, or OFSI, currently chairs the EU G7 working group on oil price cap enforcement. So essentially it is there is a body within the EU G7 which coordinates enforcement, and the UK is currently the chair of that. The shadow fleet is a priority for this group, and you've seen some recent designations, BEX active, most recently Ingerstrack on Friday. And I think the point to draw out of that is if you engage with vessels with poor AIS records, no obvious insurer, or a flag that really has expanded very rapidly in recent months, adding tankers that are engaged in sanctions trade, you do put yourself at risk. And I think it's worth emphasising that, you know, it's not a case of that you'll be okay if you do your due diligence and you get your attestations. That, of course, is what you must do, but there is no legal process in this, and the intelligence upon which UK, US, EU governments are relying to designate is not going to be provided to you. The first you will know about a designation is when it actually happens. There is no due process in the material. It's likely to happen 6 to 9 months after a particular trade has gone through, and it's extraordinarily difficult to challenge its legitimacy. You may be able to get it lifted, maybe, if you're lucky, within a period of 8 weeks, maybe a bit longer. But to actually challenge its legitimacy and its properness is nigh on impossible. The test is very, very high. It would have to be that no reasonable government agency could possibly reach that decision to designate you. So be aware, shadow fleet is a priority. Governments are looking at that very, very carefully at the moment. So vessels that fall within that broad definition of a shadow fleet, if you're engaging with those, then you are putting yourself at significant risk. Just in terms, I found it quite interesting just looking at what the UK OFSI submitted in relation to a recent UK government Treasury inquiry. Currently, OFSI has specified 29 banks. That's approximately 90% of Russia's banking sector. There's over 2,000 individuals that have been designated. There's $22 billion worth of assets in relation to the Russian regime frozen up. And there's about 172 active cases under live investigation, not including oil price cap investigations. So there's a huge amount of work going on, and that team has grown very, very significantly over the last few years. There's a lot of outreach and information gathering. Recently, OFSI conducted its first strategic communication spotlights that's focused on the maritime sector. And as part of that, they updated their guidance. They've been offering webinars and they've been offering blogs to ensure that the sanctions guidance is accessible and understood by all. Worth saying, if you're engaged in high-risk trades, they will expect you to be listening to those. From time to time, obviously reach out to specific sectors that they've prioritised, and that would recently has been oil, but it'll be other sectors in the future, and it's worth just following what they're doing. One of the other things I would highlight is that they are sending out a large number of requests for information now to people who fall within their primary jurisdiction. Businesses that are in receipt of those, your banks, your insurers, whoever, your classification society, will not be able to disclose the existence of one of those requests for information to any third party for fear of tipping off. So you should be aware that there's a lot of intelligence gathering going on all the time from OFSI, which is feeding into their decisions as to whether or not to take action against a particular party. That, of course, complements a similar exercise, which was quite widely publicised by OFAC earlier in the year. And of course, it's not just OFSI. We recently had the EU Directive 2024-1226, which so that really as from 19th of May 24, new rules have been introduced which ensure that violations within the EU can be criminally investigated and prosecuted in all member states. There's also what I would call soft enforcement, and this can take a number of different formats. Publications such as Lloyd's List have their own definition of what constitutes a dark fleet, and it would be unfortunate if you found that your vessel was named there. Certainly worth engaging with them to try and have it removed. The software such as the widely used World Check, which Mark mentioned earlier before, they tend to have a very broad sweep of sanctions references when you do a search, and in the past we've seen Ukrainian sanctions reference, which unfortunately on some occasions reference vessels that were engaging in legitimate trade, and that can be quite damaging. And be aware also that some large charterers, some of the oil majors, for example, have been, there's been suggestions that they've been deprioritizing vessels that are trading to Russia. So if you're both tendering for a piece of business to de-risk, if you like, a bit like the banks, oil majors may sort of tend to go for all other things being equal for vessels that haven't been engaged in Russia trade. So on that note, I'll just hand over to Gina.
Yeah, hi. So, I mean, over many years, the U.S. has made very clear that it's not hesitant to use the various tools at its fingertips to enforce its sanctions, the most notable being the ability to name entities, persons, and vessels to the SDN list, which has the effect of blocking the designated entity person's ship from blocking them from the U.S. market, and that has a whole host of other implications, including loss of insurance, etc. What we have seen with respect to Russia, which I think is pretty interesting, is the U.S. for a while was more careful with its enforcement with respect to commercial actors. when they align themselves with the EU and UK sanctions, most notably with the US, with the price cap, the oil price cap. Over the last 6 months, what we've seen, however, is that the U.S. will use Executive Order 14024 as the authority under which it will sanction those it believes that might be engaged in the dark fleet or other activities that they feel is supporting Russia. So EU 14024, if you pulled it up and took a look at it, you would say, I don't understand how this gives the U.S. the authority, because all it says is the U.S. has the ability, has the permission, authorization to sanction those determined to be operating or have operated in designated sectors of the Russian economy. And the designated sectors are numerous at this point. The marine sector is one of the designated sectors, as is the transportation sector. Initially, EO 14024 was utilized in that context to sanction vessels that had a true Russian nexus. They were owned or operated by Russian companies. They had some tie to Russian oligarchs. But as time has moved forward, it is clear the U.S. is using 14024 as a secondary sanction hook to sanction non-U.S. persons, foreign owners, operators, traders that are engaging in activity that is inconsistent with the U.S. sanctions against Russia. So just this last week, there were 300 entities named to the SDN list under 14024. Last month, there was another 300. There are hundreds of ships on the SDN list under this authority. We have seen ship owners, operators, managers, and their affiliated ships designated from Turkey, UAE, Hong Kong, Marshall Islands. Again, it's thus far, my impression is it's primarily focused on that dark fleet, but it's not limited to that. That piece of authority can be utilized to capture a whole host of actions that the U.S. might determine is related to the marine sector of Russia, transportation sector of Russia, or any of the other designated sectors, and the U.S. will utilize this authority to issue sanctions in the form of putting entities and persons and ships on the SDN list. So with that, all right, what's next?
So it's me, exactly. What
Yes.
next? So I think this is a double act, isn't it, Gina? As you jump in on the end, we couldn't possibly let you get away without talking about Donald Trump. So what further Russian sectors are likely to be targeted? We do have the measures, I think, coming in towards LNG. I've seen there's a question from Eleni there in the chat box, which I'll deal with when we get down to the EU 14 sanctions package. But LNG certainly, I think, is highly likely. Recently, Gina may be able to comment better, but we saw significant measures introduced by the US in relation to secondary sanctions, looking at foreign financial services business which support the Russian war economy. We will, as we've discussed, see the increased focus on the shadow fleet, and as I say, I'd repeat the warning. To as far as possible, one should avoid engaging with vessels that are part of the shadow fleet. That is a big focus of activity now. Unfortunately, you're only going to find out about whether you've crossed the line 6 to 9 months after the act in question. So we're warning people now, really, that engaging with the shadow fleet poses very, very high risks. We've been waiting for a long time for the European Union's 14th sanctions package. I understand it's imminent, but as late as Friday, was prevented from coming into force by Germany. It is likely to focus on LNG. I think the reason why Germany vetoed it was because they were very concerned about a broadening of measures that would force EU companies to ensure customers couldn't sell sanctions goods onto Moscow. So the intent probably is there to prevent that, but they're very concerned about the obligations that would be imposed on businesses within the European Union if that was to come into force. At some stage, probably in the near future, we'll see that coming through. To answer Eleni's question, we really don't know at this stage quite what form of measures are going to take against LNG. It would be surprising if they were to ban the import of Russian LNG into the European Union, simply because Russia, I think, has recently replaced the US as the largest supplier of LNG to Europe. It was historically, of course, then the US replaced it, but recently I think Russia's tipped over again, has been supplying more than the US. Increased enforcement, pattern is set to continue. And as I said, you're likely the sanctions come out, if you like, 6 to 9 months after the event. And then November, and we obviously it's a year of elections. I don't think you'll see any change in the UK. NorthStandard engages on your behalf and our own behalf with the UK government and the opposition party in the UK, and we think it's very unlikely that there'll be any significant changes in terms of UK government policy following from our election. Gina will comment further, but I think if I could just refer you to our website, where we ran an interview with an individual called David Payman, who used to be part of the last Trump administration. He in fact led the sanctions outreach from the State Department in that administration, and his comments are quite interesting as to what we can expect should we see a Republican or Trump-led presidency in 2025. Certainly a pivot away from support for Ukraine and back towards enforcement of Iranian sanctions. Obviously, we have slight differences in the law between the European Union, UK, and the US on that. That will cause us problems. And there's an awful lot of Iranian oil being shipped to Asian markets at the moment. The height of Trump-era sanctions, I think, was down to about 300,000 barrels per day. Probably today it's 1.5 million barrels per day. And some of those, there is a risk that will find its way onto your ships from STS, as if you're not very particular in the people that you're doing business with. Gina, you might want to say a little bit more.
Yes. So first, before I get to November, if I can go back a little, because you referenced the more recent sanction provision that was issued targeting foreign financial institutions. And that was an executive order that came out at the end of last year, December 2023. The number of that executive order is 14114. But what it did is it amended and supplemented that executive order I spoke to about earlier, 14024. So again, that emphasizes that 14024 is going to be the significant linchpin used by the U.S. to reach outside the U.S. jurisdiction. That new executive order that supplemented 14024 does target foreign financial institutions and subjects them to sanctions if they engage with certain persons that were designated under 14024. I haven't heard recently, but it will be interesting to see if the banks start taking a much more stringent view with respect to otherwise permissible trade for non-U.S. persons involving Russia and any transaction. It doesn't have to be U.S. dollars. It's a foreign financial institution that engages in a significant transaction with these, the sanctioned individuals. So it will be interesting to see how that all shakes out. Turning to November. Obviously, it's a subject of debate in the U.S. I think it's correct to say that if there is a change in administration, you will see a shift away from Russia, and you will see a return to Iran sanctions. I think you'll also see a further focus, a renewed focus, I should say, on Venezuela, because that is what we saw in the last Trump administration. A couple of things to keep in mind. Many of the U.S. sanctions targeting Iran and those with secondary sanction effect are set forth in congressional legislation. They're not by executive order. And so the import of that is they cannot necessarily be changed by different administrations. A particular administration may not be as, they may not exercise as much scrutiny, but the sanctions remain in place. And again, I want to hit home that other point is that activity that's engaged in today or in November could still be subject to sanctions next May if there is a change in administration. So to underscore what Mike just said, it is important to exercise that utmost diligence to try to your best to ensure you're not carrying Iranian oil, because while that is not the current cause de célèbre, it could be coming in November. January 20th is the actual change in administration. So election November, change in administration January 20th, but the activities that are occurring now can be re-examined by the new administration if there is a new administration. That's it.
Great. Thanks ever so much, Gina. I think we've had a couple of questions. Just deal with them in the last couple of minutes, if that's okay. One that's just come in about what happens when members do as much due diligence as possible. No red flag has been raised, but unfortunately, it turns out that there is a sanctions issue. And what's the impact on cover? I mean, if I just answer this briefly, I think unfortunately it's not a great message that we have to give to the members, because it's not really a question of fault. And unfortunately, there are always going to be situations where the member does do the due diligence, you do everything you can, but it's a factual inquiry that we're making when we look at a claim as to whether there is a sanctions issue or not because of a designated party or a cargo. And we obviously have to protect our position. So obviously we don't like going to the members and saying, look, we appreciate you've done everything you could here, but nevertheless there is no cover. But the reality is that may well be the situation if we know by the time that the matter comes into us that there is a sanctions issue, unfortunately. We also had one question in advance, Mike, which I'd be interested in your thoughts on, maybe just to finish, was what do you see as the biggest challenge over the next 6 months when it comes to sanctions? 30 seconds or less.
The biggest challenge over the next 6 months, I think the biggest challenge really is the communication between industry and government. I think most of industry is doing the absolute best it can, and we need, and NorthStandard needs on your behalf, really to explain what is reasonable to expect of industry. There are, of course, people who deliberately break sanctions. There are, of course, people who are very careless and end up breaking sanctions. And realistically, very, very few people have sympathy with those. But I think what's very important is that we, on your behalf, and you, to your ship owners associations, represent really what it is reasonable to expect of government, and that we're all trying to do your best, because enforcement, I'm afraid, is only going to ramp up. US, UK, and EU putting in place that directive I mentioned earlier. Thanks.
Thanks, Mike. Just one final question that just popped in about the what happens if something is technically lawful, but we're unable to provide assistance due to overcaution from the bank. Again, this is another topic which we could spend half an hour discussing. Not that I suggest we do so now, but I mean this is one of the challenges, that there's what's lawfully possible, and we will always try and help when legally able to do so, but also we do need to take into consideration what is practically possible. And so we don't want to be running off instructing correspondents and surveyors and other third parties, and then when it comes to paying them, actually we're not able to do that because the bank is just saying no. And unfortunately, it's a fact of life that we all have to deal with now, that banks' compliance policies will almost always be stricter than what's legally necessary. Gina, I don't know whether you want to just a final word before we.
I just want to. I hate. Can you hear me? I feel like I'm being disjointed. I don't want to end on a negative comment, but I do want to caution. General licenses authorize. You'll see the language. Activities ordinarily incident and necessary to X. OFAC has previously said to us or to me that that language doesn't necessarily include claims related activities that arise out of a particular claim. So I just wanted to highlight that point, because although the trade can be completely lawful under general license, if an incident occurred, an elision with the terminal, a spill, or anything of the like, OFAC's view, at least it was their view, was that you would likely have to engage with them with respect to the claim, and that the general license, because the claim or the incident is not ordinarily incident necessary to the authorized trade. So just keep that in mind if there's any incident that arises.
Great. Thanks, Gina. I think that all that leaves left for me to do is just to thank everybody very much for attending. Appreciate you spending the time to take a bit of time to run through sanctions with us. If you've got any queries, please do just reach out to any of us on this call. Alternatively, there's the sanctioned advice email address which Ursula mentioned. Otherwise, enjoy the rest of your day, and thanks again for joining.
Thank you.